Good afternoon and welcome. I am pleased to welcome you to Foley's Latin America Web Conference Series. In today's broadcast, we will address the IP rights in the cross-border landscape. Before we begin the presentation, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session as time permits. If you experience problems with Adobe Connect, please call 1-888-569-3848 for technology assistance. For audio assistance, dial star, then 0 on your telephone to reach an operator. We encourage you to submit written questions during the program. Type your question into the Q&A pod box at the right side of the presentation slides. We will respond to written questions at the end of the program if time permits. To ensure you get the most out of today's presentation, we encourage all participants to maximize the PowerPoint to full screen usage. You can do so by clicking the full screen button located above the slides. Today's PowerPoint presentation is available by simply clicking on the Download File button to the right side of the presentation. As a reminder, today's program is being recorded and will be available on Foley's website by early next week. Foley will apply for CLE credit following today's web conference. If you did not supply your CLE information upon registration, please send an email to myself, Jackie Polson, at jpolson@foley.com. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form. A 4-digit code will be announced during the presentation. Please email this code again to myself, Jackie Polson, to receive a copy of the form. And now I would like to turn it over to one of Foley's partners and one of our speakers for today, Laura Ganoza. Laura?
Thank you so much, Jackie, and thank you everybody for being here. My name is Laura Ganoza. I am a partner with Foley and Lardner, and I'm resident in our Miami office. I straddle the line between litigation and IP. I handle all kinds of complex commercial litigation matters, but I have a special emphasis in IP. And so to that end, I assist clients in clearing their trademarks and copyrights, assisting them with all kinds of enforcement issues if the need arises, and then to the extent any litigation is required, I help them navigate through that as well. And I'm here today very happy to be joined by two distinguished attorneys from Latin America. We worked very hard to make sure that this conference would not interrupt the World Cup schedule, so we did it after the World Cup was over to make sure that we could get the most participants. So first we have Diego Fernandez. He is, Foley and Lardner is fortunate to have him visiting us from Argentina. Prior to coming to start being a visiting foreign counsel with us, he was at the Marval, O'Farrell, and Maidal firm in Argentina. Diego focuses his practice on IP with a special emphasis on technology, privacy, data protection, and domain name issues. And in that regard, he's negotiated IT agreements as well as litigated domain name cybersquatting cases under both administrative procedures under the UDRP and before the Argentine courts. So we're happy to have Diego here discussing Argentina issues. And we also have Fabio Luis Barbosa Pereira. He is a partner with Verano Advogados in Brazil, and he's resident in their Sao Paulo office. And Fabio focuses his practice on information technology, internet, software, IT outsourcing, and licensing issues. Fabio has a special emphasis in entertainment and media law. And prior to joining his firm, he was in-house for a TV Global, where he was responsible for all legal aspects of establishing Futura Channel TV station in Brazil. So thank you both for joining us all here today. And what we're here to talk about is the business of IP licensing. And just in general, the reason we thought this would be a really good topic to discuss as part of our Latin American series is because licensing is really such a growing trend. And that's because of how important IP has become as part of corporations' assets. It's really, it used to be the day when assets were your inventory and your equipment, but with technology growing at the rate it's growing, intangible assets such as patents, trademarks, trade secrets are becoming what really is the core value of a company. And what is the one way to maximize that value is through licensing. And licensing allows you to look to new markets, to collaborate with others in ways that you maybe would not be able to if you were just doing this on your own. So licensing agreements are becoming very attractive, and especially in new markets and markets that are growing and exploding like they are in Latin America. So we thought this would be a great topic to discuss these growing trends. And so, but even regardless of where you are, regardless of the geography, there's always going to be key elements in any license agreement that you really have to focus on. And there are really three most important things, regardless of whether you're the licensor or the licensee. And that is, what are we getting, what are we giving, and how do we get out of this? And these are things that everyone negotiating, reviewing, or dealing with the license agreement should focus on. And what we're going to do today is focus on some of these issues in the terms of what a U.S. company may look at, and then we're also going to focus on some peculiar aspects or important aspects you should know about if you're going to enter into license agreements in Brazil or Argentina. So the first thing, what are we giving, what are we getting? When you're talking about an IP license, things that you're talking about are patents, technology rights, to the rights to exploit a trademark or a trade secret. That's really the intangible aspects we were talking about before. So if you're the licensor, you're giving away some of those rights that you may have exclusivity on with respect to those. If you're the licensee, that's what you want to be getting. What are you giving? What are you getting? That's going to be money on both sides. This is the royalties. And we're going to have some discussions about important aspects you have to consider when you're dealing with royalties in an international context. But that's what the licensor hopes to get, and that's what the licensee knows that they're going to have to give up in order to get the IP on the other end. And then what other things are you giving or getting? You're having access to things that you may not have had before, and especially with tech industries that are growing and new startups that are coming out, you might have a wonderful, great idea and a wonderful, great invention, but you may not have the capital in order to really fully exploit that. So what you may need is access to distribution, access to sales, access to markets that you wouldn't have before. Or you may be a company that has all of this, the ability to go out and sell, and you have great distribution channels, but you need research and development in order to get you a good product or make your product better in order to be able to fully exploit that. And so you see a lot of these kinds of drivers as to why people are entering license agreements. And you'll see, like in the fashion industry, for example, license agreements are very prevalent. I see those in the work that I do, and that's a great way for a brand to be able to go into new channels. So as you may have a brand known for their clothing, they'll license the rights and work with others to come out with a perfume line or a different line of accessories. And so now let's talk about what you're getting and what you're giving, but with a special emphasis on if you're going to deal with a party internationally. So you have to, if you're the licensee and you're going to be getting rights to a trademark or a patent, what you really want to make sure is that it's licensed in whatever country you're going to be exploiting the mark or the patent. So you really have to look at what has the licensor done to secure rights in either the mark if it's a trademark or the patent if it's a patent. And it's also important to look to see if it's a startup company and maybe they've gotten a patent in the United States and they've started doing some work on that, but they haven't gotten any patent protection elsewhere. There may be ability to still come within the priority period, but you have to make sure that in whatever market you as the licensee are seeking the IP, that they have the registrations to support that. And another thing, at least I've seen this in the trademark context a lot, is making sure that whatever IP you have in that country is really going to work in that country. You may see that you need the mark to be in the foreign language of that country. Well, the licensor should be required to get that registration in that, or that may be part of your negotiations in the license agreement. So that's kind of a consideration that you may have to do when you're dealing in the international context. Another thing that you have to think about in the international context is, are you allowed to license this at all? For example, and maybe Fabio can talk about this a little later, in Brazil, for example, you can only license registered rights. So if there's not an actual trademark that's registered or an actual patent that's registered, you're not going to be able to license it. And instead, so if you're the company that has great trade secrets, then how are you able to exploit that? These are the considerations that you have to think about when you're dealing in a cross-border context. And maybe, Diego, now you can talk a little bit about some of those considerations with respect to Argentina.
Sure. Thank you, Laura, and good morning to everyone. So as Laura said in the beginning, we are talking about today cross-border business. And so what we are talking now, we are in the scenario where we will have a licensor that is it's a foreign company, it's not in Argentina, will be licensing some IP rights or licensing technology to a local company in Argentina. So in that scenario, what starts to get into play is the transfer of technology regime that we have in Argentina, and something similar that Fabio will be talking about in Brazil. So what are the objectives of this regime that we have? The idea being to foster the transfer of technology to local companies, in the understanding that local companies may not have all the resources, as Laura was saying, all the resources to develop itself and be successful, not only in the Argentine market, but also going and trying to gain some foreign markets. Related to that, the idea of this transfer of technology law that we have is to provide the government or wherever the state is at the time the information as to the flow of technology that is currently occurring in the country. So say that they can with that information, what they can see if there's any weakness in any of the industries that they're trying to develop, and by means of different benefits, as we will see with this transfer of technology law, try to foster the effective transfer of technology or the license of IP rights. All of this with the same goal, trying to develop Argentine industries. I would say that in general, the system that we have in Argentina at this point in time is very favorable to licensing. And I will name 3 facts to affirm that. The first one being that is no specific form required. So actually the parties can structure the agreement, the deal, the business they're doing as they think is the best way in their own interest. So with the only limit of the public order. So the parties are free to, for example, have a typical license agreement that we see, or structure it in any other way that they think is best. The other good thing I see is that there's no prior governmental approval needed. And that was something at the beginning. When this law was enacted in 1981, related companies, the agreements between related companies needed actually an approval before being approved. But that disappeared. I think it was not more in effect in the 90s with a law that was passed to foster foreign investment. And the other thing is that this regime that we were talking about is not compulsory. So actually the parties are free, as I said, to register or not the agreements with the trademark office in this case. But if they do, and if they comply with all the requirements of the law, they will be able to get both of them, licensee and licensor, some tax benefit that we'll be talking about. So there are different rules that apply to these kind of agreements, but there are three more important sets that I think is the most important to remember today. The first one is, of course, the transfer of technology law I was talking about, that it was enacted in 1981. And actually it governs onerous license of technology and the license of trademarks, patents, and other IP rights. But it has to be from a foreign company into a local company, and there should be payments made from the local company to the foreign company. Then we have another important rule that is INPI, how we call the trademark office, is INPI Resolution 32805, that basically what was going on is from many years, the parties were trying to register different agreements. And these agreements did not show very clearly that there was a transfer of technology in the terms of the law, what the law was trying to achieve. So the Trademark Office has been rejecting a lot of these agreements on the basis that there was not technology involved. So in 2005, we had this resolution by the Trademark Office, which actually restricted registration, clarifying what technology was and what was not considered to be technology. As for example, the purchase of products were not considered technology, or for example, software licenses that go by a different channel. And at the same time, it was very important to note that what they say is that any technical assistance or know-how that was being licensed that didn't show clearly the effective incorporation of any kind of technical knowledge applied to the productive activity of the local company was not being considered technology, at least for the purposes of the law. So we was not able to register that. And then we have income tax law. I'm not an expert in income tax or tax, but this is very important because the two most important benefits that this law will give licensee and licensor, we'll be talking about that, is that they will be able to reduce the withholding tax rate for the income tax that the licensor has to pay in Argentina, and at the same time it will give the possibility of reducing, again, the amount to be paid by the licensee for its own income tax in Argentina. So which are the benefits, as we're talking, which are the benefits of registering these kind of agreements with the Trademark Office? The first one is to reduce the income tax withholding rate, and I will be talking about that a little bit later. It will also allow the licensee to deduce as a cost the payments made as royalties to the licensor. And how basically this works is, for example, say that the licensee is selling a unit that has, for example, a price per unit of $1,000, from which 700 of that are the cost of manufacture, and then they are paying $100 of royalties to the licensor. If they effectively register this agreement, and actually there's technology or a license of a trademark or a patent, they can deduce that 100 paid as royalties as part of the cost. So the net income after we deduce this 800 would be 200, over which they pay a 35% of the income tax, which would be $70. If they do not register the agreement, then that 100 that they have been paying would not be deducted. So the net income for the IRS, the base for that would be 300 instead of 200, and they will be paying 105. So as you see at the end of the day, this is about being able to pay a little bit less of the income tax, and those are probably the most important benefits that the law has. Another thing is that there's no effect to the enforceability of the agreement itself. So as I said at the beginning, the parties are free to register or not the agreement, but there are some important benefits that we are talking if you register them. In connection with related companies, as I already said, everything I'm talking today, it will apply to both related and non-related companies in the same way. They have the same treatment. So anything that is a benefit for one or is prohibited for one or the other, it will be the same to all of them. In terms of non-registered rights, as Laura was anticipating in Brazil, in Argentina, in principle, trademarks and patents you have a right to a trademark when it's registered, and you have a patent when it's actually granted. But it is possible also to license patent and trademark applications. of course, the best scenario is always to have a consolidated right and a trademark is being registered and a patent also. And the last thing I would like to mention before moving into Fabio is there are no limits for the term of the agreement. In principle, there's only one thing is good to know. We've seen a lot of agreements that is not just a license of a trademark or a patent. Most of them come with certain license of technology with some technical knowledge. So if, say that we have an agreement for 5 years, and after those 5 years, there was a success between the parties and they decided they want to renew that for another 5 years, the trademark office will, if they want to register that for the tax benefits, the trademark office will ask them to file a sole declaration explaining what is the difference between the technology that they have already received from the technology that they expect to receive in this renewal. So if there's no difference between them, then that agreement will not be able to be registered. Saying that, I pass to Fabio.
Thanks, Diego, and thanks, Laura, for the introduction. I will skip any comments on the recently held soccer event in Brazil. So I'll just go straight into the presentation. Well, technology in Brazil is, although there are a few similarities with the Argentinian scenario, even because of the proximity of the two countries, there are a few different things that we need to look at when having deals with a Brazilian company. So technology is understood as know-how in Brazil, and the legislation around technology was put together back in the 60s when the country was passing through a dictatorship situation. So if you can imagine, I mean, all the legislation that was put together at the time had the aim of trying and enhance the technology in Brazil and the acquisition of know-how by Brazilian companies. And since then, and we made a few changes in the legislation. We had, of course, different laws talking about how technology would be transferred and how arrangements around technology would be put in place. But there's still lots of things to be done in terms of like flexibilizing the agreements and the scope of how the Brazilian PTO acts in relation to technology agreements. So first of all, I mean, those points that are in the slide that you can see now are, I mean, very much what was defined as the scope back in the 60s, and then was kept until the present date. So importation and internalization of technology was one of the objectives of the Brazilian government at the time. Technology was expected to develop and enhance the national industry, so the acquisition of that technology was expected to foster, as in the Argentinian scenario, the national industry in Brazil. We would at the time be very concerned with the qualification of the internal workforce, so the acquisition of the technology and the training of Brazilian employees or Brazilian engineers and technicians was one of the concerns. So the legislation was also put together having that in mind. Of course, the independence of the manufacturing and the commercialization of products by the Brazilian entity as one of the prerequisites for the acquisition of the technology, and the increase in internal production as such. So although we can have technology agreements, of course, with foreign entities, and these can be in addition to patent and design licenses. I'll touch bases on one of the points that Laura mentioned with regard to the registration required in Brazil for the licensing of those rights. So although technology arrangements can be put in place based on know-how only, if you want, for example, to license a trademark or a design right, those need to be either applied for or registered in Brazil for this agreement to be in place. So we can have, I mean, technology transfer agreements plus several other arrangements, licensing arrangements for trademarks and designs. The Brazilian Patent and Trademark Office does not accept the concept of technology license or the licensing of know-how. So for any unprotected or unpatented technology, the right agreement should be put in place as a technology transfer. So moving forward to the current legislation on technology and technology agreements, of course, these are the main provisions. We have the industrial property law, which dates back to 96, and sets forth all requirements and all the details around trademark licenses and patent license and also technology transfer. So one of the articles there says that the BPTO in Brazil will register those contracts involving the transfer of technology. There's a normative ruling from very recently, from last year, that regulates the recordation of technology transfer agreements with the Brazilian authority, which is the INPI, just as in Argentina. We have an innovation law, which is not mentioned here, but also talks about tax benefits for innovation. And there will be conceptual differences between what is innovation, what is technology. So the technology may even not be innovative, but it can be transferred for the sake of the Brazilian legal framework. Ordinance 436 from 58, as you can see, it's a very old legislation, and that talks about deductibility limits for remittance of royalties abroad from Brazilian companies to foreign companies doing technology transfers into Brazil. There's also a law from 62, so it's the ordinance, and also this law regulating the remittance of funds. And as Laura mentioned, and as opposed to Argentina, registration before the BPTO is a requirement for remittance. So you see in the next slide that for any licensee or for any recipient of technology in Brazil to remit funds abroad or to benefit from tax deductibility or to enforce this agreement before third parties, you do need to register the contract before the BPTO in Brazil. As I said in the previous slides, I mean, the INPI or the BPTO does not accept the concept of technology licensing, although the parties can have that agreement in place if they wish. I mean, between Brazilian companies, sometimes we just do a licensing of rights instead of technology transfer, but then you don't have the benefits listed just above. So the agreements need to be registered before the NPI, and then they will have registration also before the Central Bank of Brazil to allow the remittance of royalties abroad. What happens is if you take the agreement to the Central Bank or to any bank for the remittance of funds, they will request or they will ask if this agreement has been registered by the INPI, and if it hasn't, then they won't make the remittance. So that's the problem of not registering the contract with the authority here. There has been a lot of discussion around this topic, of course, and the expectation is that we flexibilize our legislation in the future. I mean, I would say the very near future, to try and also encompass the licensing of rights, etc. So that's an ongoing discussion in Brazil. So moving forward to the main considerations around technology. So as I said, those technology agreements, they will be around non-patent technology or know-how, which is not considered a property right. So as opposed to trademarks and designs, for example, and patents, which are property rights, you have to put a transfer of technology in place and then additional contracts for the licensing of those registered rights. As Laura mentioned in the beginning of our presentation, there is a need for those patents, trademarks, and designs to be registered or applied for in Brazil for a foreign company to license them. So whenever you put a license in place for those rights with a Brazilian company, it is expected that those rights are registered or applied for by the foreign entity. So that's something to look at whenever you're dealing with either a Brazilian company or even a subsidiary in Brazil. So one of the essential aspects of the technology transfer is that the recipient may use the technology once the agreement expires. So the agreement may not have any restrictions in terms of the subsequent use of the technology. So that should be pretty much covered in the contract, in the sense that the recipient may use the technology after the expiration of the contract. They are acceptable by the INPI or the BPTO for 5 years, and for an additional period of 5 years, only if there are new developments of that specific technology, or if the technology has not been absorbed completely. So that means that you need more time for the recipient to absorb the technology. So the limits for remittance and deductibility, they will depend on the whole transaction. So if you consider, for example, a patent license plus a technology transfer, the limitations imposed by the Ordinance 436 will apply to the transaction as a single transaction, as a whole. So that needs to be taken into consideration for the royalties arrangements between the parties. So any spare parts and industrial consumption materials need to be excluded for the purposes of royalties calculation. So that's something to look at as well. We have clients, for example, that have deals with Brazilian companies. They are transferring the technology, but also the Brazilian company is importing some goods and spare parts for the production. So that needs to be taken out for the calculation of royalties. Another agreement that comes together with a technology transfer is a technical assistance agreement. I mean, it's very common for arrangements around technology to foresee not only the technology transfer but also the technical assistance. And for that, I mean, we mean any technical services for the training of engineers or for the training of technicians for the right absorption of the technology in Brazil. So that's the aim of those technical assistance agreements. And as you can imagine, Brazil is a bureaucratic country with regard to those contracts. There are a few things to follow when putting together the technical assistance contracts. So we need to put a schedule there describing the services with man-hour or man-day fees, the number of technicians involved, their qualification, the number of days that they will be rendering the services, and the total amount to be paid. So these are our requirements. The NPI will be looking into those agreements and will check if this information regarding the technical assistance is there. So it's something to worry about. Now, passing back to Laura for some consideration on the royalties cross-border, and then we'll be back with Argentina and Brazil.
Thank you so much, Fabio and Diego. And thanks for summarizing the what are we getting, what are we giving aspects of the IP that's going to be transferred or licensed. So another aspect of what are we getting, what are we giving, are the royalties. This is the money that's going to change hands between the parties. And really, there's no specific structure for royalties. It's all going to depend on the nature of the industry that you're in, the nature of the regions, and the different markets, and the type of technology it is. And different industries are going to demand different amounts of royalties. Although, as you'll talk about a little later, in certain countries, the trademark IP office may limit the amount of royalties that are permissible. But in any case, it's really going to be up to the parties to determine what is the best structure for them. And we just gave a little listing of all the different types of royalty arrangements that could come up in a licensing agreement. But specifically with respect to royalties when you're dealing in an international context, there are some important considerations that you have to worry about and place into your agreements as you negotiate these agreements because of the nature of doing business abroad. And one of them that really you should take care to address in your contract is the currency issues. So, for example, let's say you have a royalty that's based on a percentage of sales from sales in a foreign currency. But the payment of the royalty is to a U.S. company, so the payment is going to be in U.S. dollars. When does that conversion occur? The contract itself should address that. Is it going to be the conversion is going to take place at the time of the sale? Is the conversion going to take place at the time of payment? Is it going to take place at some other time in between? That's something that should be addressed in the agreement to make sure everybody understands. Another thing that is an important consideration, especially when you're dealing in Latin America, is that there's a lot of volatility sometimes in currencies, and they can fluctuate very quickly and by a great range. So what do? You have to look at that and maybe take that into account into agreements as well. And one way that you can do that is to have an average conversion rate over the royalty period as opposed to just a particular day, because maybe that day the dollar went way down. So those are kinds of considerations that you should think about in advance as you're negotiating these agreements. Another thing that you should also look at is what happens when there's blocked currency. You know, this happens sometimes, and, you know, Diego maybe can talk about it in the context of Argentina, where sometimes you cannot get money out of a foreign country, so the U.S. company that's expecting its royalty payment cannot get it because the licensee is prohibited from exporting currency outside of their country into the U.S. And for the licensee, they're going to want some protection in place for the license agreement to say that, you know, it's not a breach and it's some kind of force majeure, and it's impossible for them to perform because they're prohibited from their government from making this payment. But the licensor may also want some protections in place. And one thing that could potentially be done is to require the licensee, if there is some kind of government intervention, to require the licensee to make a payment in a specified bank where they can make the payment, and then it could be transferred whenever it could be transferred. But those are the considerations that you have to think about when you're dealing in the cross-border context. Another thing that we talked about briefly before, and Diego and Fabio both mentioned, is that, you know, you have to understand what the local requirements are for registering license agreements. As Diego mentioned, it's not mandatory in Argentina, but as a licensor, you're going to want, if to the extent that you too can take advantage of tax benefits, and we're going to talk about that briefly later, you want to make sure that any registration is being done in order to make it the most beneficial for you. Or in countries where it is required, that could also be part of the agreement and requiring the licensee to get it done by a specified time period with a specified procedure. So those are the kinds of things that you should keep in mind when you're dealing with the royalty context in dealing in South America. And now maybe, Diego, you can give us some more specifics about some royalty considerations in Argentina.
Sure. So going back to Argentina, as Dora said, you may want to know, both licensee and licensor, you may want to know upfront that there might be some restrictions to access the foreign exchange market. So that meaning that even if you have a very well-written agreement and you have a royalty rate that you think it's actually very good for your business, at the end of the day, when the licensee has to pay and transfer funds to a foreign country, the licensee might find some obstacles to do that. And in Argentina, there are currently some legal restrictions and some others that we call de facto limitations. So legal restrictions are more related to approvals by the central bank, and then you have a cap to how the amount that you can buy a foreign currency you can buy a month. But the most important part is that there have been some de facto limitations, meaning during, I think it was 2012, that the reserves of the central bank, the U.S. dollar reserves of the central bank, were dropping rapidly. So the government decided to sort of limit that in terms of, nothing was written, but when you went to the bank, to the central bank, the the petition to transfer the funds were just not accepted, not authorized, and sometimes there was just silence about that. So I think it's always good for licensor and licensee, even if they are related and if they are not related companies, to talk to local counsel to see which are at that point in time when they need to have this agreement in place, to see what are the options they have to overcome these kind of restrictions. There are always legal ways to do that. At some point, I'm not a tax expert, but at some point in time, you can buy, for example, bonds and then sell it in some other markets. There's always some ways to overcome this, but you want to know it up front, just that it's not a surprise when you need the licensee to pay. What we have seen also is that when they are related companies, so a subsidiary of, for example, a U.S. company, and there were restrictions to do that, they have just decided to invest, for example, in real estate, and at some point in time when things get better, sell those properties that they have and then be able to send the money abroad. Another thing, when we were talking about the benefits of registering these kind of agreements, we talk about the income tax withholding. So how does it work? The income tax law, the Argentine income tax law, considers that any payment made from the licensee to the licensor on the basis of this transfer of technology or license of IP right agreements are considered to be Argentine source income. So the licensor is just subject, and that payment is subject to the 31.5% general rate of withholding tax rate. That meaning that if the licensee has to pay $100, it will have to withhold 31.5 of that to pay to the IRS, and then send to the licensor only 68.5. And so this regime gives the possibility to the licensor to reduce that rate to a 21 or 28%. 21 will be the rate that you have when you are licensing a technical knowledge that is considered not to be available in Argentina. The only thing that the trademark office will ask for that is a sworn declaration that the technology is actually not available. And then you have a 28% if the technology is either available or if it's a license of a trademark or a patent. And then there's another possibility of a 10%. Argentina has in place different treaties to avoid double taxation with different countries. So if the foreign company is a corporation established in one of those countries, then in most cases that withholding tax rate will drop up to a 10%. The other thing to have in mind is the payment of foreign income tax in Argentina is allowed as a credit against the payment of the tax too. So moving to Fabio now.
Right. So as I mentioned in the beginning, I mean, in relation to royalties, Ordinance 436 will limit tax deductibility between 1 and 5% depending on the industry. So that means that for royalties remittance, there will be a limitation on 1 to 5% of the net revenue generated by the products developed with the technology transfer, depending on the industry. So the ordinance will set forth what is the percentage for tax deductibility in each industry in Brazil. If the parties are related, and that's a different thing from Argentina, if the Brazilian company is a wholly owned subsidiary of the foreign company, then the limits of remittance of deductibility will also be a limit for remittance. So that means that the Brazilian party can only remit 1 to 5% of royalties and can only deduct 1 to 5% of royalties. For non-related parties, for non-related companies, this limit is a deductibility limit, not a remittance limit. So that means that in theory, a party here or a company here can send funds abroad without limitation, and only have limitation on the tax deductibility. But I mean, in reality, what happens is that the BPTO, the INPI in Brazil, it will look into the transaction and will check whether the royalties are within the standards of that specific industry and may have a say on how much in terms of royalties can be remitted abroad. So although we can set forth, for example, between two companies, royalty payments of 60, 50%, and that happens sometimes in the pharmaceutical industry, it's likely that the NPR will come back and say, well, the standard for this industry is 20% or 30%, and then issue the certificate with that limitation. So this happens, and of course there are ways to try and have other arrangements in place or make the payments for other types of services, not only the technology transfer, but perhaps some other services that the foreign entities can render to the Brazilian entity. But those are the limitations imposed in Brazil. The calculation of royalties is normally based on the net sales of products that have that technology in the production. And for trademark licenses, the remittance and tax deductibility is limited to 1%. So now I think it's Laura will talk about some enforcement issues in the U.S.
Thanks, Fabio. Before I do that, though, I have to, at this time, announce the 4-digit code for those seeking CLE credit in Kansas, New York, and New Jersey. And it is MJMG. That's Mary, Jack, Mary, Golf. So I hope you guys wrote that down so you can get your credit. So the next thing is, so you've paid all this money, and now you want to make sure that nobody out there is using the same technology and IP rights without also having to pay for those royalties. So you want to make sure that you're able to address the enforcement issues in the license agreement. And one question is going to be, who is going to be authorized to enforce the IP rights if there is infringement by a third party? And, this is something that's very important, especially a licensor of, either patent or trademark. They really have to think about, do they want the licensee to be able to enforce their rights? Because if you have a patent and the licensee goes after a third party, and for whatever reason the result is that that patent is declared invalid, then you as a licensor may have lost a valuable asset in that case. So this is definitely an important consideration that you have to use when you're crafting these agreements. And another thing to keep in mind is sometimes, at least in the United States, it may not necessarily matter whether you give a licensee rights to enforce the IP or not in the agreement. The court is going to kind of peel back whatever labels you give an agreement and determine whether the licensee really does have enough rights in this intellectual property as a property interest, that it is the correct plaintiff in a case. And in many times, it's really going to be, it doesn't matter if you're called an exclusive licensee, and it might still have to be the patent owner or the trademark owner that's able to bring these lawsuits. So it's something that should be addressed, and let's see how it's addressed in Argentina and Brazil. Diego?
Yeah, in Argentina is a little bit different, Dora. First, as I said before, the parties have this free will. They can structure the agreement as they want, and they can, in connection with infringements and who has a standing, they can agree to whatever they think is the best in the interest of both parties. But if there's no provision in the agreement, the answer to whether the licensee can enforce the IP rights in terms of patents, the answer will be yes. There are two provisions in the patent law, two sections there, that actually say that the licensee, without making any distinction as to exclusive or non-exclusive, will have the right to exercise any of the rights of the patent owner, but it says provided that the patent owner is not doing that itself. So basically what we have here is a notification. We need as a licensee, if you're the licensee, you need to notify the licensor that there's an infringement going on or a possible infringement, and give the licensor a reasonable amount of time to take any actions. And after that time has expired, the licensee will be able to take the actions it seems that are best for its interest. In the case of trademarks, the answer will also be a yes, but there's no provision in the law. Actually, what the law says is that to become the registered owner of a trademark or to oppose to the use of a trademark, what you need is legitimate interest. And this legitimate interest has been interpreted by the courts in a very broad sense. So meaning that, for example, the licensee, and I remember now 3 cases which were decided by the Court of Appeals in civil and commercial matters, that are the courts that normally hear these cases, saying that exclusive and non-exclusive licenses have that legitimate interest because, of course, of the interest they have into not having knockoffs or counterfeits going around, being an infringement to a patent or a trademark. So the answer in this case will also be yes. In terms of copyrights, plain general principle, and there's nothing on the law, and there's no case law addressing that, I assume the answer will be a no, that we would need the IP owner, in this case a copyright owner, to take the actions unless they agree to something different in the agreement. And as you said, Laura, we always try to remind and we insist on trying to address this in the agreement. The licensor can always retain control of the proceedings. For example, can establish that it will be the one choosing the counsel for the litigation, or will fix the terms upon which the parties can reach a settlement in a court action. And at the same time, they just can't forbid the licensee from taking any action. It's up to the parties to negotiate that and find what is best. The other thing I think is important to note in Argentina is the distinction between exclusive and non-exclusive licensee, with a focus on a question, can the IP owner simultaneously exploit the IP right if it has an exclusive licensee? The patent law has a provision about that, and it says yes. Basically, it says that unless otherwise agreed between the parties, the patent owner can exploit at the same time the IP right, provided that it's doing it itself. In the case of trademarks, that is unclear. There's no provision, again, in the law, and there are no case law that are straightforward about this question. I remember a case from the Court of Appeals in civil, in commercial matters, the case is Princip Plus, that if you give some interpretation and some reading to that case, you might be able to say that the trademark owner can use the trademark at the same time, even if you have an exclusive licensee. But that's not clear, and again, it would be good to address that in the agreement. Last, I could say that parallel importations in Argentina are not considered trademark infringement. We have an international exhaustion of IP rights. What that means is that if you, a third party, imports into Argentina goods that are acquired in any jurisdiction and where you were put into commerce by the IP owner or with the authorization of the IP owner, the importation into Argentina would not constitute an infringement. So I remember a case of batteries that were imported into Argentina at a price that was extremely lower to the one that the local distributor had. And from an IP perspective, there was nothing to do about that. So that's something also that the licensor may want to know about front. Let's see how it works in Brazil.
So in Brazil, it's pretty much the same, the scenario. The law authorizes the licensee to enforce the IP rights. So that means that for patents, trademarks, designs, the licensee is able to enforce those rights. And this is a legal provision, so it is within the context of the industrial property law, so that's pretty much covered. With regards to copyrights, just as in Argentina, the author or the rights holder is the one capable of enforcing those rights. So the licensee, wouldn't have these rights set forth in law. But of course, the parties will have the autonomy of the free will, as it is in Argentina, for them to set forth in the agreement the conditions for the enforcement, for the protection of any IP rights. Licensor can contractually retain control over those proceedings, and that means that needs to be covered in the contract between the parties. One thing about Brazil is that there is a very strict product liability and consumer protection. So all the parties in the supply chain are severely and jointly liable for any damages caused to consumers arising from defective goods. So whenever you're providing a product to a Brazilian company or licensing the rights for the production, that means that you have to have very strict arrangements in the contract so as to prevent any further liability for the licensor, because the consumer in Brazil may be able to sue both the importer or the manufacturer, but also the licensor, the distributor. So then you have to have a right to recoup those damages from your partner in Brazil. So that's a thing to bear in mind always. Now we're moving to tax considerations, and I'm passing to Laura again.
Thank you, Fabio. I think we've touched on this a lot, so I'm just going to briefly just touch on some of the U.S. aspects. When you are doing having licensing agreements abroad, you do have to take care to note that there's going to be withholding taxes. So if money is going between two countries, you're going to have to deal with withholding issues, and that's something to keep in mind when you're negotiating these contracts. And one thing is, if you're a U.S. company and you're expecting to get $100, but you only get 70 because the licensee in Argentina has to withhold the 30 or so percent, you can get a credit for that in the U.S. But in order to do that, you have to make sure that all the requirements are in place, the proper registrations, and also that you have all the documentation to that end. So just keep those things in mind, and keep that in, to the extent you can, in the agreements to make sure that whatever proof you need for your government agency that you're doing this withholding, you have, and that it's part of the agreement. Diego and Fabio, I know we've already talked a little bit about the tax considerations. I don't know if there's anything else you guys want to add, or if we
yeah,
want
Laura,
to
I
move
would
forward.
very briefly, talk about the stamp tax very briefly, just to make sure that licensee and licensor knows that in Argentina, and particularly in the city of Buenos Aires and in the province of Buenos Aires, where most of the agreements are either executed or they have effects, we have a stamp tax. In the city of Buenos Aires, it's 0.8%, and in the province of Buenos Aires, 1%. Basically, what the parties have been doing to avoid a stamp tax is structure the agreement in offer letter mechanism. Basically, you have an offer, and then you have the other party accepting that offer in a separate document without reproducing the terms of the agreement. So on the basis of the precedents from the Supreme Court, if you structure the agreement in that way, stamp tax should not be triggered. And another thing is, the good news is that the Trademark Office accepts these agreements of transfer of technology or licensing of IP rights, which are executed by offer letter. So actually, it's a good way. It gives a little bit less certainty if you have to go to a court, but at the same time, it's a good way to overcome the stamp tax.
Right. And from my perspective, it's I'll just moving to the next slide. It's pretty much straightforward there. So there's those are the taxes applicable to both the transfer of technology, where you have royalties to be paid to the foreign company, and the technical assistance, where you pay compensation for the assistance given by engineers for the training of the Brazilian personnel. So as you can see, it's 25% with it's 15% withholding and 10% the economic intervention contribution for the first one, and the other one has these two plus some social security integration contribution, also the state tax, the service tax. So it can be, I mean, depending on the contract, I mean, those taxes will apply, and of course, I mean, there can be a patent license, a design license, etc. But these are the main taxes that will be applicable in the transaction.
Thanks, Fabio. And I think what I'm going to do is we have listed for your convenience some of the clauses that are considered invalid in the various jurisdictions, and they're all listed there. I think what I'm going to do is just skip those over for the sake of time and get to our last and important point that we have to always consider in any license agreement, and that is how do we get out of it. And so that's a topic that we mentioned earlier, that people sometimes worry so much about what they're paying, what they're getting. They don't always think about what happens if this doesn't work out, and you may be stuck paying for a long time or tying up your rights if you're the licensor. And in the U.S., there's different ways of dispute resolution. If there does become an issue under the license agreement, you can have arbitration, a mediation, or just go to court. Arbitration obviously has some positives in that it is a confidential proceeding, and for the most part, it can be less expensive, although sometimes arbitrations could be just as costly. But just one thing to keep in mind is to make sure to note the place of the arbitration and also the language that the arbitration is going to be in. That may be very important, especially if you're dealing abroad. Another thing is just to toot Miami's horn. Since we are the gateway to the Americas, Miami is a place is listed as a place where arbitrations can take place in kind of more of a neutral setting. So just keep that in mind when you're thinking about arbitration agreements. And we listed here the other kinds of dispute resolution mechanisms that are available. Other things you have to consider in how the contract is going to be interpreted is which law is going to apply. And ultimately, if you do get a judgment and you have a court ruling, are you going to be able to enforce that in the court where it really matters? These are all issues that you should review and think about as you put these provisions in place in the agreement. And maybe, Diego, you can talk briefly about some of these issues in Argentina as well.
Sure. But I don't see many differences between what you have said and I think what Fabio is going to say. I would say briefly that you can actually, the choice of law is something that is valid, provided that there's sufficient context with the agreement or the parties, and it's not contrary to the public order. So, for example, if you choose the law of the United States because the licensor is a company that is established, for example, in Miami, that would be something that would be valid. Again, you can also choose the venue if there are sufficient contacts, again, with the agreement. Arbitration is perfectly available. Argentina is a party to the New York Convention of the Recognition of Foreign Arbitral Awards, so they are perfectly enforceable in Argentina. I think the only thing a court may want to see if there's no public order in any of the decision or the agreement or what was being resolved there. And something to keep in mind, both for licensee and licensor, is that even if there's a choice of foreign courts or arbitration, that will not prevent the parties from going to a local court for interim remedies.
Okay, and in Brazil, I mean, the scenario is sorry, I'll move it here. Okay, so the scenario is pretty much the same as in Argentina. So we have a dispute resolution process that can be either judicial or through arbitration. So arbitration is fully accepted. Although the choice of jurisdiction is possible in the contract, I mean, it may not be binding because if there is a public interest or a matter of public order, the Brazilian courts may consider themselves competent to trial a lawsuit. So although the parties can set a jurisdiction abroad, I mean, it may be the case that the licensee will file a lawsuit in Brazil and the courts will trial that suit. So that's one thing. The second thing is that choice of law, again, depending on how the agreement is performed in Brazil. I mean, of course, if there will be a transfer of technology and most of the agreement will be performed in the country, then again, the choice of law will be possible, but the judiciary may be deemed competent to trial that lawsuit. So one good thing to do is to have an arbitration provision, as Diego mentioned, Laura mentioned as well. This is fully available. The arbitration awards are enforceable in Brazil. Brazil is a signatory of the New York Convention. And the law and the seat of arbitration can be chosen by the parties, of course, taking into account all those considerations that Laura mentioned at the beginning regarding the language, the number of arbiters. So those things are things to consider always. And as Diego mentioned, just as in Argentina, we do have the possibility of interim measures or remedies being taken by the parties, so the licensee may be able to go to a court of law to claim any rights as an interim measure, even though arbitration is set forth in the contract. So I think that's our last slide in the presentation. I'll move it back to the presenters.
Thank you, Fabio and Diego, and thank you everybody for your attention. Sorry we ran a little over, but I think it's because we were providing a lot of good and useful information. Here's our contact information if you have any questions. And also, just so you know, I know we went through a couple of the slides a little quickly, but the PowerPoint will be available on Foley's website within the next 24 to 48 hours. And there's a link to that there, so you can definitely pull up the presentation and have that and use it for future reference. Also, we really would like your feedback. We'd love to know what you thought, and if you have any comments about additional topics or things that you would like us to speak about on these Latin America conferences, there's going to be a survey that's a link to the survey that's provided to you, and you can just click on that and give us your feedback. So, Jackie, is there anything else that we need to provide?
That is it. Thank you.
Okay, thank you, everybody.
Thanks a lot.
Thank you. Bye-bye.
This concludes today's conference. Thank you for your participation.